All rise.
The Kosovo Specialist Chambers is now in session.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
I failed to say good morning to everyone, so good morning. The SBO and defense were both introduced yesterday. I don't intend to do that again unless there's somebody new sitting at any of the tables. Nobody here? Anybody new? Mr. Rees?
Yes, I'm assisted also today. I'm assisted also today by Miss Victoria Maud.
I'm sorry?
By Miss Victoria Maud.
Thank you very much. And from the registry, somebody new?
Good morning. Thank you, Mr. President. I'm Ralph Ridge from the registry, and also here today is Stefan Wolfart, the Deputy Registrar.
Thank you, Mr. Roach. Today we will finish our agenda as set out in the July 21 order. Then we will hear the parties on the Rule 102.3 list, and if need be, in an ex parte session. If we are to have an ex parte session, we will take a 30-minute break before that to allow court management to make the necessary preparations. After the lunch break, we will resume for the panel to issue a number of oral orders. The first topic on the agenda for today concerns the confidential or non-public nature of the material allegedly disclosed by the accused. I give the floor to my colleague, Judge Barta, for his questions on this topic.
Thank you, Mr. President. In the 21st July order, in paragraph 24, the trial panel took note of the challenge of the Gucati defense, as indicated in its pre-trial brief, as to the confidential or non-public nature of the material allegedly disclosed by the accused. The panel invited oral submissions from all parties regarding the question whether the material allegedly disclosed by the accused was of a confidential and or non-public nature. I would like to ask the defense first, starting with counsel for Mr. Gucati, to clarify whether its position is that the material was already in whole or in part in the public domain, and if so, which part or parts, or for some other reason, the material did not enjoy confidential or protected status under the applicable regime, or the SPO failed to establish that the material enjoyed such status. After that, the SPO will be invited to respond. Mr. Rees, you have the floor.
Thank you, Your Honour. It is our position that, firstly, the information was already in whole or in part in the public domain. That has been acknowledged in relation to large parts of Batch 2 by the SPO, and the defence pre-trial brief has set out such other parts of the information that we can identify in the absence of full disclosure of the batches being provided to us, save, that is, for the disclosed public part of Batch 2. And secondly, that the SPO have failed to establish that the material enjoyed the status of confidential and or non-public. That also, of course, includes that the SPO have not demonstrated the material enjoyed confidential protected status under any applicable regime. And we hope in the defence pre-trial brief we've set out at some length the various provisions that we rely upon to raise that issue. Thank you.
Thank you, Mr. Rees. Mr. Kedman, do you have anything to add?
Your Honour, just simply to put, we have at all stages endorsed and adopted the same position put forward by Mr. Rees. We have also set out quite clearly that in the absence of being able to scrutinise that material, we are unable to take the position any further. And in the absence of the trial panel being able to scrutinise that material, there are concerns as to the trial panel being able to take that position any further. We have at all stages put on record that the SPO are put to strict proof on establishing the confidential and non-public nature of that material, and that remains our position.
Thank you very much, Mr. Kedman. Mr. Prosecutor, would you like to respond to that?
We would. Thank you, Your Honour. Everything that is being relied upon in the batches falls within the protected information articulated in particular in paragraph 37 of the confirmation decision. As said yesterday, everything the defense did and said made it clear they understood that the materials delivered were confidential. The primary thrust of the Gucati defense arguments concern the classification of the documents delivered rather than their authenticity as such, but the SPO will introduce evidence set out previously when discussing authenticity that the materials delivered were confidentially classified. The judges will receive evidence as to what is in the batches and can examine extracts of them in media articles and other evidence to assess the secrecy of the information. In this regard, a distinction must be made between general cooperation between the SPO and government authorities and specific requests demonstrating that cooperation in action. The general arrangement may be publicly known, but it is a different matter entirely to link specific officials and locations to a criminal investigation. And we intend to prove at trial that was the case. Thank you.
Very well. Thank you, Mr. Prosecutor. Those were my questions. Thank you, Mr. President.
Thank you, Judge Smith. And the questions are for the defense. Mr. Rees, I was very much assisted by your brief, particularly on this matter. There is, however, a gray area in your brief that I want to ask you about. I understand you take issue with the confidential nature of the material. Putting that to one side, the prosecution is relying, and it's just been said a moment ago, that your client and the client of Mr. Kedman understood that the matters or that the materials delivered were confidential. And in fact, in their own pretrial brief, the prosecution is relying upon a number of pieces of their evidential puzzle that suggest that both Mr. Gucati and Mr. Haradinaj referred to that material as being confidential and or secret. And what I want to ask of you is whether you have a position in respect of this part of the prosecution case. Of course, again, if you prefer not to do so at this stage, this is entirely your decision. But we would be assisted if we were to understand what your position, and I will come to Mr. Kedman in a second with the same question, is in respect specifically to these indications.
I can assist with that question, Your Honour. The remarks that are recorded as having been made by the accused have to be seen in their context. And whereas there are remarks from the accused that appear on the face to acknowledge confidentiality, there are other remarks that are recorded where they make the position properly clear, which is the accused did not know whether the documents were authentic or false. And of course, if they were false, any appearance of confidentiality would likewise be false. Mr. Gucati is not a lawyer, and his remarks need to be seen and acknowledged as remarks not made by a lawyer. Obviously, if disclosure had been made, these matters could have been properly checked, but they haven't. Disclosure hasn't been made, and therefore we rely on the position as we spelled out yesterday, and as is spelled out in the defence pre-trial brief. The accused did not know whether the documents and any markings on them purporting to indicate confidentiality and or internal work product were authentic or false.
Thank you, Mr. Rees. Mr. Cadman, if the submissions are identical, maybe you'll qualify that in respect of the fact that your client is a lawyer, we are told. But can we have your position on that particular issue?
Your Honour, put simply, the position is identical. The same position will be put forward. And the position that we take is that the trial panel will have to observe all of those video recordings, all of the press conferences, and all of the remarks made in the media to put all of those matters into context. Of course, I do accept that my client has some legal training, and of course I'm sure he'll be happy to explain his legal training when he ultimately gives evidence at trial. But our position is very clear that it would be insufficient for the trial panel to scrutinise the transcripts of the recordings. The trial panel will have to observe all of those recordings to put all of these matters into context before it can draw its own conclusions.
I'm grateful, Mr. Cadman. If your client is intended to be called as a witness, may we remind you not to forget to put his name on your prospective list of witnesses at the time when you provide your final list on that point.
As I'm sure Your Honour can appreciate, the list that has been put forward at this stage is provisional. We are not required to set out the extent to which a defence case will be presented, but in the event that we do, that will be made clear.
I'm grateful. Anything from the SPO in response?
Just briefly, Your Honor, in relation to Mr. Rees's submission, when talking about what the accused did and said, I think I mentioned the defense, what the accused did and said. Just to point to paragraph 40 of the confirmation decision in defining eventual intent and what the necessary mental element is and how neatly it fits into even the explanation the defense is trying to give. That's all.
Thank you.
Thank you, Judge Metro. The next topic on the agenda concerns any future challenges by the defense as to the elements of the charged offenses and the modes of liability. We only ask the defense to indicate whether they intend to challenge any such elements. No need to go into details at this point because more questions on this subject will be asked at this SPO's preparation conference. Mr. Rees?
We do.
Okay, Mr.
We do, Your Honour.
All right. Thank you very much. As I said, the panel may have more questions for the parties at the prep conference, the SPO's prep conference, and we'll wait for that. Next is the use of the Facebook account by the Gucati defense in its pretrial brief regarding the use, submissions made by the Gucati defense in its pretrial brief regarding the use of a Facebook account. In relation to this topic, Judge Metro has asked to ask some questions.
Thank you, Judge Smith. In order of the 21st of July, the panel took note of a submission made by the Gucati defense according to which, and I quote, "The accused accepts that there was a Facebook account in his name which he had access to and occasionally did access. He did not, however, have sole access to the account, and it was used by the KLAW VA staff and family to post material." In the same order, the panel indicated that it would invite the Gucati defense to clarify whether it disputes the SPO's claim that any of the impugned posts were posted by or with the knowledge of Mr. Gucati on his Facebook account. So, Mr. Rees, if you are minded to respond to the panel's invitation that's your time.
Your Honour, I'm very grateful to note that the request is clarified as an invitation and not an order, no doubt reflecting that the making of any defence admissions are entirely voluntary and not required. I will respond in two ways. Firstly, by asserting, as we do, that our defence pre-trial brief consists of very full voluntary defence disclosure, and secondly, by adopting the remarks that Your Honour made yesterday morning to Mr. Hallin, when Your Honour anticipated that the answer to the defence in relation to these Facebook postings will be that we don't have to put anything forward, it's for the SPO to exclude that possibility, and we rely upon that position.
And maybe just to clarify this, having acquainted ourselves with your brief, and indeed your brief is quite an extensive iteration of your position, may we take it that you are not planning either on calling evidence in respect of usage of this account, and are not intent on identifying any given individual who could or might have had access to that account during the relevant period. You are simply, as we understand it, putting the prosecution to strict proof that it was your client who is responsible, or at least has knowledge of the posts in question. Is that a correct understanding of your position?
We do put the prosecution to strict proof. We do on all elements of the case, and I have to prove it as part of the prosecution case. There is one aspect which is a misunderstanding on my part, which I think has become clear to me from Your Honour's comment to Mr. Cadman in relation to Mr. Haradinaj and whether he will be given evidence. The list of proposed defence witnesses that was submitted with the pre-trial brief refers only to those additional witnesses over and above the accused, Mr. Gucati himself. If it was the case that if we proposed to call him to give evidence, we should have put his name on the list of defence witnesses, then I apologise, that's my fault and my misunderstanding of the role of the list of proposed witnesses. If there is any confusion, I'll clarify that, Your Honours. At this stage, we do propose to call Mr. Gucati to give evidence if at the end of the prosecution case we are of the view there's a case to answer. I hope that does clarify matters, and that also may explain the perhaps misunderstanding, which I hope to have clarified yesterday, which is when I said that the assumption could be made that anything that's in the pre-trial brief, any factual assertion, we do propose calling evidence to support. I hope that does assist.
It does assist, Mr. Rees, and we are grateful for the indication, and I'm sure that the prosecution would be grateful too, insofar as they now have an indication that you may make the decision to call your client. That's going to be a decision for you to be doing at the end of the prosecution case, whether you feel there is a need to do so. But we're grateful for the indication.
Thank you, Your Honour.
Anything else?
Mr. Cadman, sorry.
Just to add to that, as Your Honour will be aware from the record of these proceedings, the Facebook posts amount to several thousand pages of material that require to be reviewed. At the time of filing the pre-trial brief, we had requested additional time so that we could consider that material. We did not set out our position in a pre-trial brief as far as that, but our position as far as Mr. Haradinaj is the same as that of Mr. Gucati.
Thank you.
The next topic concerns submissions made by the Gucati defense.
Apologies, Your Honor. Is it possible for the prosecution to respond?
Go ahead.
Thank you. And I will be brief, because I appreciate that this was discussed yesterday. And we talked about how in our submission, this is an issue of weight and not of admissibility. But just to respond to something that Mr. Rees said in particular, no, the prosecution is not denying that we are held to strict proof on this point. But it is a question of circumstantial evidence who is posting these things. All available evidence, as discussed yesterday, is pointing to the fact that these are Gucciati's posts made by him or on his authorization. The competing inference, as of this moment, is a submission from counsel in the pretrial brief. The defense is not obligated to present any evidence in this trial, but there is currently no second inference that can be drawn from the evidence as to where these Facebook posts came from. And so that is our submission. And that's why when I said yesterday, something needs to be presented to create that second inference, it's not because the defense is obliged to give evidence, it's because the state of the evidence now suggests that this inference is unreasonable. Thank you.
Just one matter in response to your submission, Mr. Halling, is you are right that at this stage it's only an assertion of counsel, but counsel has now given you an indication of their intention to call evidence on each of the facts that they alleged in their brief. And that means one thing for you is that the burden that you have is to be met as part of your case in chief in relation to these facts. So to the extent that you bear that burden, you are now on notice that there is at the very least an intention by the defense to call evidence on these issues. And I suspect you imagine why this warning is being given. You are on notice of the nature of their case and their intention to call evidence on these assertions.
We understand you fully, Your Honor.
Anything else? No. The next topic concerns submissions made by the Gucati defense in its pretrial brief as regards to the retention of material. In relation to this topic, I give the floor to my colleague, Judge Mitro.
Thank you, Judge Smith. It's going to be brief. In our 21st July order, the trial panel took note of a submission by the Gucati defense, according to which, and I quote, SPO officers had previously informed KLA WVA persons that they could retain such material for up to 1 month. And in the same order, we indicated that we would invite the SPO to clarify its position on this assertion and whether it takes issue with it. The panel also notes, before we give you the floor, Mr. Halling, that in their submissions, both defense teams have now identified a witness under number 2 of their list, who is to be called inter alia with a view to give evidence upon the claim that he was, and I quote, told by SPO officers that the KLA WVA could retain the document after lightning one for 1 month. So, Mr. Halling.
Thank you. The SPO strongly takes issue with this assertion. It fundamentally contradicts all evidence of the speed which the SPO sought to recover the batches. And there's no evidence in any of the contemporaneous official records as to something like this being said or discussed or even said in a way that could be misconstrued to mean what the Gucati defense is alleging. The defense presents very little specificity of this claim. The remark Your Honor mentioned in the witness summary and this one sentence in their recent submissions is the most detail that we have, which makes it unclear what they're claiming was said and to what this remark referred. After the defense pressed this claim, because they mentioned batch 1, we once again spoke to the SPO security officer who led the operation to serve the first order and seize batch 1. The officer has signed an official note confirming that he never said anything like that as alleged by the Gucati defense. Should any further information be provided, we will investigate this as well. And just for interest of disclosure, we do intend to disclose that official note, and we will do so this week. Thank you.
Mr. Halling, if I was to give the floor to the defense right now, I'm sure they would turn your argument on you and say at this stage we only have counsel argument in relation to that, no evidence of it. The question is, the indication again is given now by the defense that beyond the assertion there's an intent to give evidence in relation to that fact. Whether it's accepted and relied upon is, of course, a different matter, but at least there's an indication that there is such an intent on their part. The follow-up question is, will the prosecution seek to lay evidence on that matter, or are we going to do or deal with it solely on the basis of your submissions?
Our submission is that this is fabricated. And so we are not at this time planning on leading evidence in our case in chief in relation to it. And that when we challenge the evidence of the defense, whatever it is, our current position is that that is sufficient on its own. Should further information necessitate revisiting this position, of course, we appreciate we would need to seek leave of the trial panel. But there is no evidence in any of our records that this exists, and leading evidence to disprove something that, again, doesn't seem to have happened in the slightest is not currently something we feel that we need to do.
Anything either defense wants to?
Well, it is, of course, a matter for the SBO how they run their case. But it seems that the trial panel is simply going to be asked to take Mr. Hannon's word for it. That's not how a trial, or at least any trial that I've ever participated in, usually proceeds.
Let me just endorse that position and add to it the fact that we have requested of the SBO on more than one occasion statements taken from the officers who were present on Operation 1, 2, and 3. None of those officers are currently listed to give evidence at trial. We have been refused the opportunity to see any statements from them. And our position is that we will not have the opportunity to cross-examine any of those investigators or even be given the details of those investigators, bar one officer.
Thank you.
Excuse me. Moving on, I invite the parties to indicate whether they intend to submit any motion pursuant to Rule 117 sub 2, other than the motions that are already received pursuant to the 21 July order, or those that you indicated during this conference that will be filed in the near future. And if so, also indicate the subject matter of these applications and whether you are in a position to file such motions by 17th September, with any responses to be on file by the 24th of September. This would allow the panel ample time to consider and rule on them. I'll first start with the prosecutor.
Your Honor, we have no further motions other than what's already been forecast and have no objection to the briefing schedule.
All right. Mr. Rees?
It seems to us, Your Honour, that there are two main categories outstanding. The first is the determination of the admissibility status of the material that's been identified in the defence pretrial brief list of objections to admissibility, which may correspond. I haven't quite gone through yet to see if they correspond entirely, but they may correspond with the content of the SPO's bar table motion. As I submitted yesterday, we do support the determination of those matters before the opening of the trial, because clearly that will have potentially a significant impact on the actual shape of the trial when it begins. The other matter is disclosure. And at the moment, I'm not in a position to give any detailed forecast as to how I see those matters pan out, because, of course, we are conscious that following Your Honour's oral order yesterday, the completion of the Rule 1023 notice is outstanding. There is, we understand, an application to be made today for redactions by the SPO, although we've had no real notice contrary to Your Honour's order yesterday evening. or we were told moments before you came into court this morning, orally, was that there would be an application by the SPO for an ex-parte hearing in which they would raise Rule 106 and Rule 108. Remarkable, it would seem to us, that we had that briefest of conversations when we've been here. We were here in the building until 7 o'clock yesterday evening. We have email accounts where the SPO can reach us at any point of the day, yesterday evening, this morning. And we certainly don't think what was, frankly, a shoddy attempt to meet Your Honour's direction. We think it was nothing of the sort, frankly. Your Honour required them yesterday afternoon to provide prior notice to the extent about the nature of their objections to disclosure. And we certainly have not had that, and we certainly didn't have it in a timely form to allow us to consider it at all. So I'm afraid we do see ongoing issues with disclosure. Exactly how that's going to pan out, I can't say at this stage. I certainly would hope and will aim to meet the aspiration of the trial panel that any such motion that we may have to make, we will do by the 17th of September. That's all I can assist with at this stage, Your Honour. Yes, Your Honour.
It will come as no surprise, Your Honour, that our position is identical to that of Mr. Gucati. And can I just also make the point that I share Mr. Rees's frustration in the way in which this matter is being handled. We have raised in the past that whilst the SBO has consistently said throughout these proceedings over the last 8 months that their disclosure is complete, each and every time we approach a hearing before this court, we receive additional material, moments, sometimes a couple of days before the hearing. That really needs to stop. We will be making additional applications for disclosure. We will endeavour to abide by the guidelines and the timelines set by the trial panel, but that will depend upon the response that we get from the SPO moving forward.
Any response from the prosecution?
Briefly, although not in relation to the question asked by Your Honours, in relation to the notice for the hearing today, we were refining our position right up until we went into court this morning. It was not ready at 7 o'clock last night, for instance. We didn't have very much time before the hearing because of the timing in which the defense teams arrived to give more information. When this issue arises, if the defense require more time in order to meaningfully respond, we have no objection to that, but we have given, as you'll see when we get to that issue, we have given the main arguments that we intend to present, and we believe that we've complied with Your Honor's instructions.
You've given a full notice of the nature of your objections, as I ordered yesterday.
We have, Your Honor.
Mr. Cadman?
We don't accept that.
Obviously. All right. I would ask the prosecutor. Go ahead, Mr. Rees.
All we've had is reference to the two rules that they propose to refer to. And it is at odds with what you were told yesterday, Your Honour, by Mr. Hanning.
Were you given a written notice?
We've had no written notice. Right. Literally, we had, as I said, moments before you came into court this morning, literally seconds, we were told that they will be relying on Rule 106 and 108, and that's it. Yesterday, of course, Mr. Hallin said that the nature of any objection would be not an objection as such, it was an application for protective measures. So accordingly, I spent yesterday evening and this morning looking at the relevant provisions for protective measures. I did speak in the interest, as we have done throughout, to try to engage with the SPO on an inter-parties basis before this hearing started on Tuesday. And I went to speak to my colleagues in the Specialist Prosecutor's Office about this very issue, about Rule 1023, and was met with the simple response, Court of Appeal have made a decision, they didn't order it, nothing to do with us, not interested. We had no discussions at that stage because they were not interested, and we have not had notice today, contrary to Your Honour's order yesterday.
This is not sufficient. Your office will, within 1 hour, provide to the defense a complete written statement of what the nature of your objections are, not by mere reference to rule sections. Is that clear?
It is, Your Honor.
This is about disclosure, and disclosure is an essential part of these proceedings. And playing hide the ball is not disclosure. We expect better.
Understood.
We'll move on to the last topic on the agenda from the July 21st order, and it concerns the presentation of cases. And in this regard, as indicated in the 21st July order, I ask the SPO to indicate the following: whether its estimate as to the time necessary for the presentation of its case has changed, especially in view of the additional proposed witness, and which counsel are expected to appear on behalf of the SPO during the trial proceedings. You can answer that at this time, Mr. Prosecutor.
Thank you, Your Honor. In terms of the time necessary to present the evidence of the two witnesses on the list of witnesses, there are no changes. Obviously, we would need a revised estimate for a third witness if leave is granted to call that witness. In terms of counsel giving appearances, at trial, the SPO will be represented by myself, Ms. Valeria Belici, Mr. James Pash. We, along with our case manager, Ms. Lena Peterson, will intend to appear at all hearings. The only other persons who may present submissions to you in this case from our office would be the SPO's senior leadership, such as the Deputy Specialist Prosecutor, who is in court today.
Thank you. Now I turn to the defense. Ask you to indicate what each defense team's estimate as to the time necessary for cross-examination, if any of these two witnesses might be, and whether each defense team will opt to give an opening statement directly after the opening statement of the SPO, or an opening statement after the closing of the SPO's case and before the opening of the defense case, or no opening statement. And I realize some of that depends on when and how the SPO's case ends. I also would like each defense team to estimate as to the time, if any, necessary for the presentation of their case, if you can do so. Should either defense team decide to call a case, what its estimate is to the time needed for preparation after the closing of the SPO's case, and which counsel are expected to appear, the same question that I asked the SPO. Mr. Reese, you have the floor.
Thank you, Your Honour. Because the progress of the SPO case is rather unusual, I found it not a simple task to give estimates. So I've prepared what I think are realistic worst-case scenarios. I think they will err on the side of pessimism, and I hope that actually at trial things will be more speedy. I've also considered with Mr. Cadman time for the defence cases, because we're conscious that there is real overlap between the witness lists, and conscious that of the draft direction in the conduct of proceedings that exhorts the parties to consider sharing witness requirements, as it were. So I will give an estimate, I think, for the defence cases, assuming that all witnesses are called, as it were. I think in relation to witness one, I will call her that because rather than the longhand pseudonym that's been attributed, but witness one She is given a schedule which is some 397 rows long, 9 columns. Her declarations run to a total of 117 pages. We will have to explore if her evidence is admissible on these matters. That schedule in real detail, trying to keep my questioning concise, but bearing in mind that I have not seen any of the material that the witness presents an analytical report on, together with her questions about her conduct of the search that took place on the 25th of September. I think I could be up to 7 days in cross-examination with her. In relation to witness 2, who produces a report based on the 107 official notes of contact with witnesses, that's how they're described, with the witness 2 only being involved in 15 of those 107 notes personally. Again, if that evidence is admissible, with limited disclosure, and appreciating that I'm dealing with a witness who's given effectively third-hand evidence, not just second-hand evidence, all of which is contentious and in dispute, the accuracy, reliability, truth, credibility of the people concerned. The only way I can explore all those matters is through this single witness. I think I could be up to 5 days with witness number 2. Again, his declaration and exhibits run well over 100 pages. I do not propose making an opening after the SPO's opening.
You do not?
I do not. At present, I do consider an opening after the closing of the SPO's case and before the opening of any defence case. I think that on the basis that both defendants and all defence witnesses are called, the best estimate I can come to is that that evidence should take no more than 3 weeks. In relation to a break for preparation of the defence case after the closing of the prosecution case, the time that is envisaged in the registry's submissions on the conduct of proceedings order seems to me to be that practice direction is clearly drafted with cases of a different nature in mind, it seems to us. So we don't seek for a period as long as that's envisaged in that direction. We think a week should suffice. That leads us to a position for an overall approximate time estimate, including what we think is appropriate time for the prosecution opening and, of course, the plea.
Go ahead, I'm sorry for the interruption.
The prosecution opening, the playing of their videos that will have to be played during the course of the trial, which we calculate amounts to approximately some 3 days' worth of footage, together with incorporating the estimates that were given for witness 1 and 2 in chief in the prosecution's pretrial brief, and allowing some time, although we don't know quite how much, for the third witness that the prosecution have indicated they will seek to call. We obviously don't know the content of his statement yet, but allowing some time, that would amount to a total period of some 9 to 10 weeks. In terms of counsel, I intend to be present throughout. Mr. Bowden will be with me. There are some, I've consciously kept my commitments in other matters as limited as possible for this term, although there are some unavoidable commitments that I have. They're few and they are short in duration. And I will ask in due course for the trial panel's assistance and flexibility on my part to allow me to meet those other commitments. There are only some 5 or 6, and they're on specific days. But on those days, Mr. Bowden will certainly be here to assist with this case so that it shouldn't impede progress. And obviously, again, I would ask for some flexibility with the SPO in terms of how we schedule the work that needs to be done on those days to assist. Unless I can assist any further with those matters, Your Honour.
Yeah, I have one question. You're perfectly aware that another trial will be taking place in the same courtroom, and so we are going to be sharing time. So when you say 3 weeks, do you mean 5 days, 3 weeks of 5 days, 15 days, or do you mean 3 days in which we have 2 days in this courtroom? 3 weeks in which we have 2 days in this courtroom?
Well, certainly, although of course we have speculated amongst ourselves as to how, with the single courtroom, things were intended to progress with another proceeding.
I can tell you,
us,
and maybe it's a help to everyone, that when you're sharing this courtroom, and we can't work every single day because we have translators and other court proceedings going on at the pretrial stage, we will probably get 2 days per week when we're in session. And we have been offered 2 full uninterrupted weeks at the end of October, which would mean we could get 8 full days of trial in probably during that time period. So just so you can quit speculating a bit and understand, that's how we will end up having to share this space in the future.
Well, that's very helpful, and we're grateful for that to be made clear.
It may seem that we're hurrying here and trying to get as much done as possible, but we are mindful of 2 things. One is we have those 2 weeks available to us at the end of October, and number 2, your clients, as we're quite aware, are in detention.
Absolutely.
And we want this case to be brought to trial in an expeditious way, and I hope everyone understands that and can look forward to that.
Absolutely, and at the bar, both defence and prosecution discuss this matter, and everybody is of the view, not least because, primarily as Your Honour has said, that Mr. Gucati and Mr. Haradinaj have been in custody now for almost 12 months, that we all agree that it's imperative that the trial starts as soon as possible and concludes this calendar year.
Thank you very much.
The periods I've given were intended to incorporate what we envisage to be obvious delays, in the sense of we did not envisage the court sitting every day through those periods.
Okay. But
So,
when you said 3 weeks, do you mean 15 days of trial?
no, I meant blocks.
Okay, all right, that's good. Thank you very much. That's very helpful. Mr. Cadman, same questions, and if it's the same answer, we don't need to go through it again.
Your Honour, just to make it clear and easy, Mr. Rees and I have consulted, and so the position put forward is on the basis of the presentation of the defence cases. So the time estimates that he has set out are the same. In terms of counsel, the counsel represented today will be represented throughout the trial. We do not envisage any change to that. And we are also equally keen, Mr. Haradinaj is very keen to have this matter resolved before the end of this year as well.
And we will do our best to advise everyone about of our planning thoughts, so you can start incorporating those weeks, those days into your calendars. We can't really do that today. We need to get this the next meeting under our belts, and then we'll probably be in a good place. And bear in mind that I am negotiating and discussing with the other trial panel all the time on opening times up. That's how we got those 2 weeks at the end of October. The other panel wasn't going to use it, and they offered that. So we're trying to cooperate as well. Thank you very much.
The only addition I would make is that we have calculated on the basis of the defence investigations, representations made by Mr. Howling previously, of an estimate of early November. So even if it's brought forward a couple of weeks, then I don't think that's going to cause any insurmountable difficulties for the defence.
Thank you. We will we will enter an oral order this afternoon in regard to some of these questions that I asked today. In our July 21st order, we indicated a provisional date for the SBO preparation conference for next week on Wednesday and Thursday, the 8th and 9th of September. Is this, I know we contacted you earlier to see if that was available. Is that still going to be a workable date for you, Mr. Prosecutor?
Yes, Your Honor.
Mr. Reese?
Yes, Your Honor, thank you.
Mr. Cadman?
Your Honour.
Very good. Thank you for the cooperation on that. I realize, as I said, we're condensing somewhat the time available to us. At the Specialist Prosecutors Preparation Conference, we will be, as required by the rules, setting a date on which to open the trial. And it has to be within 30 days, so it gives us a fairly good idea of where we're heading. I will tell you that we are anticipating a date to open the trial and to hear opening statements only on October 7th and 8th, and then to begin hearing evidence on October 18th, continuing, as I said earlier, through the 29th, two full weeks of available dates. We'll discuss that. I don't want you to commit yourself to this today because it takes a little bit of thought and planning on your part, I know, and so we will, I'm mentioning these so you can think about them and be prepared to discuss them in earnest next week at the trial, or at the prosecution's preparation conference. Okay, Mr. Cadman?
Sorry, one point I didn't set out, and that is a defence opening. Our position is the same.
Oh, I'm sorry.
We would not be giving a defence opening until the close of the prosecution case,
Understood.
if we get that far.
I'm sorry. I assumed that, and I shouldn't have done that, but thank you.
Thank you.
Anyway, keep in mind these dates that I've set out, and we will do our very best to live with them. So we've reached the end of our agenda that was scheduled. One other thing, Mr. Haradinaj's defense had raised an issue concerning private laptops. Has that been dealt with now?
It has been.
Thank-
I'm very grateful to
Thank
the
you.
registry for that.
And thank you to Registry for facilitating that for us. Any other issues you wish to bring up for this hearing today? Nothing from the prosecution? Anything, Mr. Reese? I know we have one large thing waiting, and I realize that, and we'll get to that soon. But Mr. Cadman, anything you want to raise? Any other issues?
Not at this time, Your Honour.
All right. Gentlemen, do you want to go back? Do you want to go right in?
Microphone.
because of the need to have the updated document from the SBO delivered to the defense, we will break until 11 o'clock. We will be ready to start at that time. Please get the document to them prior to 11 so they can look at it before we begin. All right, we are in recess until that time.
Your Honour.
Oh.
Just very briefly in that regard, if once we see the document, we will try to be ready to deal with it at 11 o'clock. But if, having seen it, we would request more time to consider it, is it possible that we can send a message through the trial panel just asking for that,
Just
delaying the start?
Just get to Vicky and.
Thank you.
Yeah.
I'm grateful.
All rise. All rise.
We are back in session. We have received a copy of the notice and have read it. And we the defense indicated they needed some additional time, but we will start with the prosecution statement now, and then break, and come back for the defense, and then go on from there. I appreciate everyone's patience. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. Your Honor's direction called for a discussion on redactions to the Rule 1023 notice materials relating to the process by which these batches were disclosed to the KLA War Veterans Association. You asked for an inter partes discussion, but for purposes of that discussion, we would ask to go into private session.
Your Honor, we are now in private session.
Thank you, Your Honor. And our arguments are going to be derived from the notice that Your Honors have just indicated you read. We apologize to the court and to the defense for the delay in this regard. It's not our intention to hide our position on this or any other matter. And going forward, we'll bear Your Honor's admonishment in mind. We have a continuing investigation into the deliveries of the batches. It is sensitive and ongoing. We consider it to be highly damaging to this investigation to reveal anything about how these deliveries came to pass, as it, amongst other reasons, creates opportunities for further illegal disclosure. Listing these materials with any detail at all, as indicated in Rule 102.3, is going to inevitably lead to revealing the lines of our investigation and how all this happened. If listing materials implicates restrictions on disclosure that exist in the rules, Rule 106 and Rule 108 being the relevant restrictions in this case, then it is our submission that the trial panel can order the non-disclosure of that part of the Rule 102.3 notice. Rule 108.1 permits withholding information disclosable under Rule 102, not just Rule 102.1, the entire rule, when doing so would prejudice ongoing or future investigations. To the extent witnesses provided information to the SPO, disclosing this information could also pose grave risks to their security. The rule entitles the SPO an opportunity to make ex parte submissions on whether to withhold this information in whole or in part. In addition, parts of the materials constitute internal work product under Rule 106 of the rules. Rule 106 expressly provides that reports, memoranda, or other internal documents prepared by a party or victim's counsel, their assistants, or representatives in connection with the investigation or preparation of a case are not subject to disclosure or notification under these rules. We are under no obligation to notify such materials, and therefore we should not be required to list them on a Rule 102.3 notice. We request permission to make ex parte submissions to give the trial chamber further detail on the constituent elements and risks to providing notice to describe our investigation on this matter. In other words, we are prepared to give a meaningful description to the judges on what would be in the updated Rule 102.3 notice that's contemplated. We are prepared to do this orally or in writing if the trial panel is inclined. If the trial panel is inclined to do it orally, Mr. Whiting is prepared to address the trial panel on this today in an ex parte session with all further details. Thank you.
I have a question for you, Mr. Holling. You have known about this decision, about the decision of the Court of Appeals panel since July 29th. The decision clearly stated that the relevant material should have been included in your Run 023 list. Why would you only now request some sort of a redaction or ruling of protection for these things? Why do we wait till the trial prep conference to do this when it was quite clear, to me at least, in my reading of the decision, that it should have been done?
The answer is because of the disposition of the appeal decision that you're referencing. The pretrial judge made two rulings in the impugned decision leading up to that appeal, one on 1023 notice and a second on disclosure. Had the appeals panel wanted to reverse the decision or remand it back for the notice that Your Honor just foreshadowed, we would have expected them to do it in the ruling. The appeals panel did not do that. They confirmed the ruling in whole with no further order attached. And in our understanding, that meant that the error on ground one identified was harmless. And it makes sense that it's harmless because the whole point of the Rule 1023 notice is for things to be selected such that there can be a focused discussion on the materiality of the information in question. Once the appeals panel upheld the pretrial judge's finding that there was no prima facie materiality shown by the defense, there's no point in listing them at that point. We would have just gone in a circle. We would have provided the notice responding to ground one, they would have selected it, and we would have ended up in the same place. So the way we read the Court of Appeals decision was that no further action from us was required, despite the error found on ground one. And this is at least the explanation as to why we proceeded the way we have.
Well, that's an interesting reading. Any questions? Go ahead, Judge Mutro.
Thank you, Judge Smith.
Is there any objection that we return to public session now?
Without knowing what further questions will be asked, it's hard for me to say, but I leave it in your Honor's hands if you think it
We'll
can go
return to
back.
public session.
Your Honors, we're back in open session now.
Thank you. Now your question.
Thank you, Judge Smith. Mr. Halling, I want to go back to briefly to this issue of materiality. Assuming your understanding of the appeals chamber's decision to be correct, isn't it the case that the inability of the defense to demonstrate materiality is closely linked to the absence of a list of items that they can review, at least as a general indication that there is something in your possession that could be material to them? If they are not in possession of such an instrument, how do you suggest they would be able to make that demonstration in the first place? And that leads me to a second point, which I would be grateful for your submissions, which is in the material that we are talking about now in a very and unfortunately very abstract way. Does this material contain potential evidence of any of the material facts that the defense is putting forward as being relevant to their case? You, the SPO, are the only one who have seen that material and have the benefit of it. Our rules provide a principle of disclosure with exceptions that you have to, in relation to which you carry an onus. So, two questions. Number one, do you accept that the inability of the defense to meet this prima facie stage of demonstrating materiality is tightly linked to your failure up to this point to give them a list, number one? And number two, are we talking of material which, on the basis of what you know from the defense pretrial briefs, plural, could be material to establishing any of these facts? And I'd be grateful for a specific response to the extent you can do that in public.
Thank you, Your Honor. The short answers to your two questions are, for the first one, not always and not in this instance. And the answer to the second question is no, but I'll expand on both. As for the link between the Rule 1023 notice and materiality, it is clear from the appeals panel's ruling that they did not consider that to be necessary in this instance. In other words, if ground one's error had bled into ground two, then they would not have confirmed the decision. They would have remanded it back for the notice to have been provided and then to have relitigated the materiality. The Court of Appeal did not consider that to be necessary, which means that that particular link that Your Honor is identifying, although it may be true in other contexts, they did not see it. It's also not seen from the way that the defense was behaving, because what the defense could have done is they could have sought leave to appeal only in regards to the Rule 1023 notice and then relitigated materiality at a later point. They didn't do that. They sought leave
I'll stop you there, Mr. Halling. I'm sorry, but assuming your reading to be correct and a technical, reasonable understanding of the appeals chamber decision, what do you think will happen here? The defense will make the request for the list, which they have, and having reviewed that list, they will ask for the documents to be disclosed to them. So now we have effectively have to relitigate the issue and therefore to take a position on this issue. That's the situation we are in, instead of, as a result of the appeals chamber decision, taking the proactive step of assuming that this was coming and, if necessary, to seek the measures, the confidentiality measures that you are now seeking for us. So I join Judge Smith's comment on the delay that we note in your office's failure to do that as an earlier stage.
Yes, and on this, Your Honor, our position was that this matter was settled at the pre-trial phase of the proceedings. Structurally, the whole point of having a pretrial judge at the KSC is to resolve matters like disclosure before this case is transferred to the trial panel. We understand now that the trial panel is interested in relitigating this issue. But the entire point of that interlocutory appeal was to resolve this question once and for all so that revisiting this issue was not necessary. Obviously, the trial panel is entitled to ensure, they have the obligation, in fact, to ensure the fair and expeditious conduct of the proceedings. And if it is in the trial panel's determination that further discussion of this issue is warranted, that is the trial panel's prerogative. But it is not necessary to revisit this issue because of the Court of Appeal decision. Were it necessary, the Court of Appeal would have said it. It would have been remanded back and the litigation would have continued before the pretrial judge. As to the second question, as to whether there is any information in this material that would be relevant for the defenses that are raised, no. We have reviewed the material in light of what the defense has raised. There is nothing in it. I appreciate what Your Honor is saying, that you're taking my word for it. How can you know without getting more information about the materials yourself? We appreciate that. And this is why we're asking for an opportunity to make ex parte submissions to provide more information, following which the trial panel will be more informed. And so we again repeat this request to you, to the court, and yes, that is our position.
Thank you.
Thank you, Mr. President. Mr. Halling, thank you for your submission so far. I'd like to ask you a couple of questions about the SPO position, about the ground for non-disclosure of reports, memoranda, or other internal documents which have been prepared by the SITF or the SPO in connection with its investigative work, which is set out in the final sentence of Rule 106. Now, this privilege against disclosure, which protects both the defense and the prosecution, is about internal work product. I want to clarify what exactly is the internal work product here. Is the internal work product in part material which you say was unlawfully disclosed in a manner that amounts to a criminal offence as part of the actual substance of this case that we have before us? And separately to that, I can imagine that there is internal work product which has not been, in your submission, unlawfully and criminally disclosed. Now, which is it that you are refusing to disclose to the defence under Rule 106?
Your Honour's question is difficult to answer in public session. I will try.
I can just assist you with a little bit. If there is information which you say falls under the Rule 106 provisions concerning non-disclosure, and it is also information which has entered the public domain as a result of what you say were criminal activities, does that really fall within the Rule 106 internal work product privilege? That's what I'm getting at.
When we mention Rule 106 in this context, we're not referring to those materials.
And are you invoking Rule 106 at any stage in respect of those materials?
We are and have. And this goes to the decision of the pretrial judge authorizing non-disclosure of the 3 batches in particular. So we've already fully ventilated our position on that. But what we're talking about now, because there's already been a ruling on the batches, is a different set of materials, not all of which are work product, but some of which are.
Okay, and I just want to return to the purpose of Rule 106. The reason that the internal work product privilege exists. Would you consider that the purpose has been somewhat rendered irrelevant once the internal work product has entered the public domain due to what you say are unlawful and perhaps criminal activities?
Our position would be no in answer to that question. Our internal work product can be waived if we give it to third parties. We understand that. But this is not what happened in relation to the materials that we're discussing. The SPO never waived its internal work product. And if the idea that something wrongly disseminated into the world would deprive it of its character as work product, then it would, in a sense, perpetuate the wrong in question. And this is, so when the pretrial judge rendered the decision, we to this day consider that batch 3 in particular is internal work product of the Specialist Prosecutor's Office. That is unchanged by the criminal conduct of the accused.
But does that material, once it has entered the public domain, does it not become the very essence of the crime which you say took place? It's now completely entered into a new character, if you like. It becomes part of the element of the crime.
It still doesn't, because it's not in the public domain. It was, if something is wrongfully disseminated, and in this instance, not everything that was wrongfully disseminated appears in the public domain. There are pages of batch 3, for example, that were distributed, but were not necessarily revealed in any media article or any other place. So when you have a situation like that, the document itself didn't lose its character just because this happened, nor is the information within it all in the public domain. We can't lose our internal work product protection for that reason. A crime can't take away the privilege that we had, as Your Honor described it, for our internal work product. And so but again, this discussion is different from the discussion that we're talking about now. We're talking about different materials, and again, an ex parte session we can explain further.
I have no further questions. Thank you, Mr. President.
I want to give you the opportunity to respond to what's been said thus far here in open session, if you wish. Mr. Rees.
I'd like to reserve our position, and I will deal with all matters later when we reconvene.
All right.
Thank you.
Likewise, Your Honour.
All right. So we will reconvene at 2 o'clock. That was your request, was it not? 2 o'clock, and be prepared. Hold on just a second. We'll reconvene at 2 o'clock, and prosecution, you should be prepared to go into ex parte session if it's so ordered immediately following that session. Everyone understand? All right, that's all. Thank you.
All
We're in
right.
recess.
rise.
Good afternoon, everyone. We're back in session to hear the submissions of the defense on Rule 1023, detailed notice or list. Mr. Rees, you have the floor.
Thank you, Your Honour. All right, if I can begin with yesterday's position of the SPO. Yesterday, the trial panel was told, in response to the oral order that Your Honour made, that if it's the SPO's position that updating the Rule 1023 notice would involve revealing information that would be subject to protective measures, even just on the list, is it within the scope of your Chamber's briefing schedule to file a request to the Chamber with sufficient time to rule upon it by the 6th? Yesterday, the SPO was not sure that any such material would require any measure, and the only measures under contemplation were protective measures under Rule 80. Rule 80, of course, involves consideration of protective measures for the protection, safety, physical and psychological well-being, dignity and privacy of witnesses, victims participating in the proceedings and others at risk on account of testimony given by witnesses. It's related specifically to the use of material at trial. And of course, Rule 80 also directs both the applicant and the court to consider the nature of the measures that are being sought, specifically with a view to making sure any interference with the usual trial process is kept to an absolute minimum and only as necessarily required. And it specifically refers to, for example, limited measures, redacting names, using pseudonyms, non-disclosure to the public, redacting information on the Specialist Chamber's public records, and so on. The use of private or closed sessions are ways to deal with any such risk. And indeed, restrictions on further disclosure of that material and its use. Today, we are told that, in fact, the SPO now appears to apply a blanket approach. I say appears to because the email that we received at 10:35 today gives no real indication to us as to the extent of any such interference with the golden rule of disclosure that the SPO seeks. So I can only draw the inference, I may be wrong, perhaps the SPO could assist on this, but I can only draw the inference that they apply some blanket approach to all material that falls within the scope of Your Honour's oral order yesterday, despite their clear equivalence on the position yesterday. The notice explains that the SPO is undertaking a continuing sensitive investigation into deliveries of the batches. Pausing there, it is of note that the assertion is that their investigation is continuing, despite some bold conclusions having been expressed by the SPO in the past in open sessions. They have not reached the end of their investigations, which either reveals a willingness to play fast and loose with oral submissions in court, or indeed a closed mind as such investigations are continuing as to what those investigations will ultimately reveal. The notice continues by email. The SPO considers it to be highly damaging to this investigation to reveal anything about how these deliveries came to pass, as this would inter alia create opportunities for further illegal disclosure of confidential material. There's nothing in the email which explains as to how or in what way such opportunities might come about, or indeed what confidential material the risk of further illegal disclosure relates to. They continue that Rule 108.1 permits withholding information disclosable under Rule 102 when doing so would prejudice ongoing or future investigations. I pause to add as an observation that the Specialist Prosecutor, in public press releases and interviews with the media, is more than happy to express his belief as to the source of the process which led to those deliveries, without any evidence, seemingly completely regardless of the risk of prejudicing those ongoing investigations by making such public statements. And I've referred to them in the defence pretrial brief. I won't repeat them or give them any further airtime now. It does seem to us that the risk of prejudicing ongoing or future investigations is a factor which the SPO seeks to play with when it suits them and to disregard when it suits them to so disregard. The email continues, in addition, parts of the material constitute internal work product under the Rule 106 of the rules. There is no indication given to which parts or how extensive that material is. It does not cover the nature of the category or type of internal product which is said to fall under Rule 106. The SPO is under no obligation, it says, to provide notice of such materials and therefore should not be required to list them on a Rule 102.3 notice. The SPO does not acknowledge that Rule 103 does provide within it, Rule 106, I apologise, does say that the Rule 102 notification requirement is subject to Rule 106 unless otherwise ordered by a panel. I make the point that Rule 106 provides a wide discretion to the panel to order such material to be subject to disclosure or notification, not just under Rule 103, but also notification under Rule 102.3. That's a wide discretion that the panel has under Rule 106. The email finally provides the SPO will request authorization to make ex parte submissions in order to provide the trial panel with further detail concerning the risks of providing notice and details concerning the SPO's internal investigations. It is a general principle that where ex parte submissions are to be made, proper notice should be given to the defence, as specific as the nature of the material allows. And it is necessary to do so to enable the accused to make focused submissions to the court. There is no suggestion that we have, indeed, the way in which the notice unfolded, as it were, with Your Honour raising notice yesterday afternoon, the SPO having all night and this morning to properly consider it, a 1 minute verbal chat before the trial panel came in, and then a hastily cobbled together email, again purporting to comply with Your Honour's direction, hardly suggests that the SPO has given proper thought to providing such notice as specific as the nature of the material allows to enable the defence to make focused submissions to the court. I submit as well, this is, I'm drawing, because of the hasty nature of this application, I am drawing on authorities from the jurisdiction of England and Wales, but only to such extent, in my opinion, as they support general matters of principle. The Court of Appeal of England and Wales has said that great caution is necessary in the handling of ex parte applications to restrict disclosure made in the absence of the defence. There should be the most searching investigation by the prosecuting authorities and by the courts of the facts relating to matters in respect of which non-disclosure or authorisation to be excused from disclosure obligations is claimed, coupled with the most searching consideration of their possible relevance in the light of whatever defence is being advanced. And I endorse that as a general principle which should be applied in this chamber also. What is apparent from the email is that the material the SPO seeks to withhold appears to be extensive. That is contrary to the impression, at least, that was painted before the pre-trial judge and the parties. As an example, on the 30th of March of this year, at the status conference held on that date, as recorded in the transcript of these proceedings at page 197, line 16 to 20, Mr. Pace, on behalf of the prosecution, said that they had disclosed, the SPO, we have disclosed, as we have said before, and we've informed them before, the information we have about steps taken regarding the potential identity of the person who dropped documents off at the KLA War Veterans Association. In particular, there was one interview which we provided to the defence. At the very least, that was economical with the truth, it seems, now. In relation to that interview, as it happens, and you will have seen a reference to this in the defence pre-trial brief, that interview was an interview following the revelation to Mr. I won't name the officer, but an SPO officer, on the 16th of December, with the index number of a vehicle that appeared to have been the person making the delivery on that date. As we have asserted in the pre-trial brief, the SPO officer appeared to be seemingly disinterested in that information and was effectively forced to take it. And that impression was reinforced because no attempt to check that index number was made until the 25th of November 2020. And it was not until the 18th of December 2020 when, again, Mr. James Pace interviewed that person. An interview which we have had disclosed to us, and we have had the name of the witness disclosed to us. I won't refer to him. So there didn't appear to be any of these great concerns about revealing details of the investigation of the process by which these batches made their way to the KLA-WVA at that stage. What we see in that very short interview is the person confirmed to Mr. Pace that, in fact, it was his vehicle, although he wasn't in the area, he doesn't remember where he was, wasn't involved. To which Mr. Pace effectively says, "Thank you very much, I've no further questions." And that was it. As we've described in the pre-trial brief, and we will explore at trial, a seemingly a sham interview, from which we say, together with other evidence, you can draw the inference the SPO knew all along the identity of that person and persons who were involved, and were not interested in pursuing it at our request. You were also told earlier on today that the pre-trial judge, in his decision on the prosecution requests and challenges pursuant to F00172, ruled on an application by us that the Rule 1023 notice was deficient. He did not. he ruled on a single issue, as is clear from paragraph 58. He ruled on the issue as to whether the evidence that we said, without the assistance of Rule 1023 notice, but we had done our best to try and specify the material that we thought may exist. He ruled on a single issue, which was whether that material should be disclosed under Rule 1023 or 103 of the rules. Now, that's made clear in paragraph 58 of his judgment, and in the final judgment, paragraph 64. The SPO, whether advertently or inadvertently, make assertions that are incorrect. And I urge some caution on your part as a trial panel before relying on such assertions without proper scrutiny of them. The decision of the appeals against disclosure decision of the Court of Appeals Chamber here, file in IA005, does touch upon the history of disclosure in these matters. That history, if I may, I will take a moment to recount, because it demonstrates what we say is an approach to disclosure and disclosure obligations by the SPO, which is not characterized as one of constructive engagement, but is instead one of evasion. Their approach to a disclosure obligation is how to evade it, rather than constructively engage with it. At the outset, in relation to the scope of Rule 1023, we submitted that Rule 1023 of the rules created a multi-stage process which was new and was not reflected by the other international criminal tribunals in this city. And we were right about that, despite the SPO's resistance to it as a proposition. It is a multi-stage process. The first step involving the SPO to provide a detailed notice of any material and evidence in its possession that is relevant to the case. The Court of Appeal, as the pretrial judge did, agreed with our submissions that the concept of relevance to the case has to be interpreted broadly, and that the test for relevance for the purposes of that first step is not the test of relevance that have been applied in other international tribunals that do not have that first step. It is a test that is wider than the test of materiality to the preparation of the defence, which, conflating the various stages in Rule 1023, the SPO purported to follow, and still, it seems today, maintain, despite the ruling of the pretrial judge, confirmed by the Court of Appeal. Contrary to the approach adopted by the SPO, relevance to the case the Court of Appeal held, as we submitted, was not limited by the scope of the charges against the accused. Specifically, contrary to the firm approach the SPO sought to apply, the process through which the information arrived to the KLA-WVA premises was relevant, as we had submitted from the off. The SPO have provided two versions of a Rule 1023 notice in the past. The first version, dated 19th of February 2021, filing 00133 in Annex 1, had 13 items on it. We said at that stage that it was a paltry effort to comply with the obligations of Rule 1023, and we were right, as the pretrial judge ruled. The SPO had prepared that first version with only 3 items, setting out firmly for the pretrial judge, making one of their assertions that they wanted the pretrial judge to accept at face value, that it fully satisfied with their disclosure obligations. They were wrong about that, as the pretrial judge ruled, which led to the addition of a further 171 items, the vast majority of which have, as it happens, been subsequently disclosed to the defence following the revelation of their existence and content only by that notice that we had to argue for. The material went on the list. Once we had it, we were able to properly argue that it should be disclosed as material or exculpatory, and that's been accepted and we've received it. Material which, if we had left the SPO to their own devices, we would have been completely unaware of. The second and final version, up to Your Honour's order as of yesterday at least, the second and final version of the Rule 1023 notice was again prepared by the SPO on an erroneous basis. Namely, that any material or information in the SPO's possession relating to the process through which the information arrived to the KLA-WVA premises was not relevant and was not required to be put on the listed on the Rule 1023 notice. As Your Honour ruled yesterday, the SPO must now revisit the Rule 1023 notice in the knowledge that any material or information in the SPO's possession relating to the process through which the information arrived at the KLA-WVA premises is relevant and must be listed on the Rule 1023 notice unless Your Honours authorise otherwise in accordance with the statutory regime. Specifically, the Court of Appeal held, as well as that broad approach, that any material or information in the SPO's possession relating to the process through which information arrived at the KLA-WVA premises is relevant and must be limited. They specifically held that any material in the prosecution's possession which would fall under Gucati requests B and C is relevant and must also be included in a revised notice, as paragraph 57, where the Court of Appeal in the judgment held that the pretrial judge had erred in not requesting the material identified under Gucati requests B and C be included on the Rule 1023 notice. Those requests were as follows, and I'm going through them, Your Honour, because in the absence of proper notice and in the absence of a Rule 1023 notice that has been revised in accordance with Your Honour, with Your Honour's order, indicating, if necessary, where proposed redactions are required, complying with the understanding that the golden rule is full disclosure and only the minimum derogation is necessary. The SPO could have done that if they wanted to constructively engage, and at least we would have had that further information as to the extent of this material, how many items it is, what material can be listed on the Rule 1023 notice. We don't have that. We don't have a fuller application. So I will go through the requests because it does seem to me it's relevant for the SPO to consider them specifically, because they don't necessarily ask for internal work documents or reports. They ask for the information. And there's a difference between an internal work documentation and the information upon which an internal work product is based. And as I read Rule 106, there is no exclusion from the disclosure obligations of the information upon which such a report is based. The report itself might be protected because it might have all sorts of things in it, like the opinion of the specialist prosecutor or the belief of the specialist prosecutor, which frankly, as long as he keeps it to himself, I'm not interested in the slightest. But the base information, the facts upon which such a report are prepared, is not covered by Rule 106, and if relevant, should be listed on a Rule 1023 notice. So we asked under Gucati Request B, all material held by the SPO which relates to the origin and provenance of the material contained within the 3 batches, including material as to authorship and chain of creation from custody from creation to its arrival at the KLA-WVA HQ. Well, I accept that a report on it might fall within Gucati Request B, but as I say, it's the information underlying the report that we're interested in, not anyone's opinion on it at the SPO. Gucati Request C, all material...
Could the Council please slow down for interpretation? Thank you.
...to the KLA-WVA HQ.
Counsel, they are asking you to slow down a bit when you're reading.
Sorry. Thank you, Your Honour. I will do my best. Like with pressing the button on the microphone, I may forget Your Honour's exaltation, so please stop me again if I don't slow down. So Gucati request C was that all material held by the SPO which relates to attempts made by the SPO to identify and trace the individuals making disclosure of the 3 batches to the KLA WVA headquarters. Again, I accept that there may be some reports that fall within that category, but it's the underlying information that is disclosable and not covered by Rule 106. But the request went further than those categories. They were drafted, of course, at a time when we were deprived of the assistance of our proper Rule 1023 notices, the Court of Appeal recognised. And they were drafted at the encouragement of the pretrial judge, who, when he did rule in our favour on the initial Rule 1023 notice dispute, when at that time there was a 13-item list, the pretrial judge, in order to expedite proceedings, said to the defence, when you receive the updated Rule 1023 notice, and there's material on there that you think should be, but isn't, don't worry about the Rule 1023 notice, come back to us and ask for disclosure of it. And if there's an issue on materiality for disclosure purposes, the pretrial judge would deal with it at that stage. That's how we jumped from stage 1 to stage 3, as the Court of Appeal recognised, without properly completing stage 1 process and allowing us to properly complete the stage 2 process. But we did do our best to try and be as specific as possible, and the requests incorporated the following. In relation to the material identified as batch 3, said to be composed of 2 incomplete copies, counting 244 and 245 pages respectively, of an SPO document pertaining to SPO investigations and official proceedings, and which constitutes internal work product dated December 2019, but further references dating to March 2020, which current or former SPO staff members, including investigators and counsel, contributed to its creation. That does not ask for a report or internal work product, it asks for the information. Which current or former SPO staff members, including investigators and counsel, had access to the document electronically? That does not ask for internal work product or memoranda, it asks for information. Which current or former SPO staff members, including investigators and counsel, had access to the document in hard copy form? That does not request any report or internal memoranda or internal work product, it requests information.
Mr. Rees, is it possible for you to wrap up in 5 minutes? We only have so much time today and we can't go into tomorrow, so.
Well, if I'm... No, I do follow that, Your Honour, and I will try and be as brief as possible. 5 minutes will be unlikely, and given that this is an oral application that's been forced upon us without us any opportunity for us to make written submissions, I do not have much more to say, but I do have some things that I want to say, and I would do my best to keep it as concise as possible.
Skip to the most important ones then, thank you.
Well,
wait just a second. Mr. Cadman has something.
In the interest of time, and not wishing to repeat anything that Mr. Rees has set out in detail, I'm more than happy to give my time to Mr. Rees so that he can set this out.
He's already into your time. All right, thank you. Go ahead, Mr. Rees. Please do your best.
I'm grateful to Mr. Cadman. I will try and be as concise as I can.
I know you will.
But I do want to go through this list because it does seem to us that the SPO, they do not ever take us up on our invitation to look at detail at these questions. And it does seem to us they almost ignore it because they make an application now which doesn't address the decision of the Court of Appeal and the matters that we raised beforehand. We're not asking for internal documents, memoranda, reports, we're asking for information. Was the document password protected? If so, which current or former SPO staff members, including investigators and counsel, had the password? Are all such SPO staff members who had access to the document or had any passwords still SPO staff members? Does the SPO still retain an electronic copy of the document? Has the metadata on the document been checked for evidence as to the last person to access the document? And if so, who was that person? Has the SPO identified the computer upon which that document was created? Who are the regular user or users of that or those computers? Where were such devices located? These are questions seeking information, facts, not reports, not internal memoranda. Have any current or former SPO staff members been interviewed about the disclosure of the document? Have any current or former SPO staff members been interviewed about the disclosure of the document? Have any electronic devices used or controlled by current or former SPO staff members been interrogated for evidence of disclosure of the document? Have any email accounts or other remote communication facilities used or controlled by current or former SPO staff members been interrogated for evidence of disclosure of the document? Were any hard copies of the document stored on SPO premises? If so, was there any CCTV coverage of the area or areas of storage or the access routes to said areas? If so, has such CCTV been examined for evidence of access to and from said areas? The Court of Appeal agreed that material is relevant. It's the information that's relevant, not the report, not the opinion of the SPO, the comments, internal memoranda. That information is relevant and should be on a Rule 1023 list. Not restricted to those specific questions, because, of course, all material relating to the process through which the information arrived at the KLA-WVA premises is relevant, but it should include specific answers to those requests as set out by the Court of Appeal. I add as well that the Court of Appeal made clear that those requests, being relevant as they are, they need to be reviewed for disclosure, not just in relation to the issue of entrapment, but all wider issues. And I can't assist the panel with that at this stage because I don't have any information on the Rule 1023 notice to give me a better indication as to what material is there. But if you do go into ex parte submissions, the SPO and yourselves will have to try and consider all potential uses, all potential relevances to the defence, not just in relation to an issue of entrapment. The suggestion from the suggestion of the SPO this morning, I think, as Your Honour put it, an interesting reading of the Court of Appeal's decision, that the Court of Appeal's decision was final and disclosure matters are for the pre-trial phase, and therefore they did absolutely nothing about the failings in disclosure that were clearly identified in the Court of Appeal's decision. Again, suggests to us, confirms to us, what has become apparent, that the SPO looks at disclosure as something not to engage in, but to avoid or evade. The Court of Appeal's decision was clearly qualified in that it was based on the information before the pre-trial judge. On that basis, on the basis before him, they said he wasn't wrong to refuse disclosure. That's because we had jumped from stage one. We'd missed stage two without completing stage one. And the judge was faced with, I concede now, broad applications for disclosure without the assistance of the Rule 1023 notice in its proper form. What the Court of Appeal made clear, in simply confining its decision to the decision that the judge ruled on, which is not to make disclosure on the basis of the information before him, the Court of Appeal nevertheless reminded the SPO, it's there in paragraph 53, it's there, of course, in Rule 112, that the disclosure obligations of the SPO are of a continuing nature. They don't just stop with the Court of Appeal decision on an interlocutory basis where the Court of Appeal knew that the matters would go back in the first instance to the pre-trial judge and then on to a trial panel with the SPO having continuing disclosure obligations under, inter alia, Rule 1023 throughout the course of the trial and indeed after the trial. The defence should not, well, I'll put it a different way. The SPO appear content that the defence continue to bear the burden of identifying in the abstract, in the absence of any list, which material it requests with specificity, despite the fact that all of the material should already have been placed on the SPO notice. They appear to be perfectly happy with that, and the trial proceeding on that basis. They appear to be perfectly happy with the defence continuing to be deprived of the benefit of such a notice, with a higher burden unfairly placed upon it to identify with specificity material not in its possession and potentially not even within its knowledge. The criticism is clear there in the Court of Appeal decision, but the SPO are perfectly happy, it seems, with the defence continuing to suffer that deprivation. The SPO appear to be perfectly happy with the defence continuing to be deprived of a complete first stage of Rule 1023 of the rules. And any proposition repeated today, it was made before the pre-trial judge, and repeated today, that the listing of items in the Rule 1023 notice is without object, where it's already apparent, to whom, we don't know, but already apparent that they're not material to the preparation of the defence. That proposition was raised, and the Court of Appeal singularly rejected it. If the obligation under Rule 1023 is to list all material that's relevant, that's what the SPO does. And the rejection of that proposition, repeated today, is in paragraph 46 of the Court of Appeal's decision. We submit that the SPO should comply fully with the order that Your Honour made yesterday, with a revised Rule 1023 notice listing all relevant material and information in the possession of the prosecution, including material relating to the process through which the information in the batches arrived at the KLAWVA premises, should be prepared. And that first stage, the very first stage of disclosure, should finally at this late stage be complied with. To the extent that there are then any new requests for disclosure of material from the list and the determination of them thereafter, that will necessarily follow the completion of stage 1. Under Rule 108, the SPO, again, by placing, it seems to us, at least from the brief email, primary reliance on Rule 108, the SPO again conflate the principles of notification under Rule 1023 with the making of disclosure, because Rule 108 applies to material that's otherwise subject to disclosure under Rule 102. Under Rule 108, of course, the material can be withheld in whole or in part. We have not had the assistance of the SPO to tell us whether they do seek the withholding of the information in whole or in part. And of course, although we had at an earlier stage requested disclosure of this material, I acknowledge the decision of the Court of Appeal panel, which is that I should wait and hold my fire until I receive the Rule 1023 notice. So again, in my respectful submission, we are again at the invitation of the SPO being asked to jump directly to stage 3 of the process, the disclosure questions, because they seek to rely on Rule 108 to authorise non-disclosure. I do not know, because the email we've received is silent upon it, whether the Specialist Prosecutor will propose any counterbalancing measures that are where the Specialist Prosecutor is specifically exhorted to consider under Rule 108 sub-Rule 2. Those counterbalancing measures could include the submission of a summary of the information, or submission of the information in a redacted form. As I said earlier on, perhaps the most obvious way of dealing with this fairly would have been for the SPO to have taken cognizance of the obvious criticisms in the Court of Appeal panel, put together a addendum draft addendum for the Rule 1023 notice, they could have provided that to us with the proposed redactions marked upon it. And we could have then had a specific argument over those particular redactions, which may have made the process much more concise and easier to follow, and would have allowed us to engage more than in the vague way that we are thus being permitted. So I do not know whether there's any proposed counterbalancing measures to be suggested. In relation to Rule 106, as I said, and as the SPO ignore, it is clear on the face of Rule 106 that as a trial panel you have a wide discretion to order the disclosure and notification of such material, even if it does fall within Rule 106. I do note, and this may well have been in Your Honour's mind this morning, when asking Mr. Halling about the disclosure of material into the public domain, that consistent with the submission I make, that the underlying information behind an internal note, report, or memoranda is not covered by Rule 106 in the way that the report itself might be. Of course, once material has been made public, even if it is in an internal note, that internal note is not covered by Rule 106 anymore. And I rely on the authority of Niyitege Teg, I'll spell it, Niyitegeka. If Your Honours have access to Archbold on International Criminal Courts, Practice, Procedure and Evidence, I think it's the 5th edition, Your Honours will see reference to that and the proposition that, for example, a question put to a witness from an internal note is not an internal note anymore for the purposes of the protection of Rule 70A of the rules I think before the ICTR, but it's at Chapter 7-297 where that is referred to. I am drawing my submissions to a close. But before I do so, I wish to address one aspect of the Court of Appeal's decision, and that's the presumption of good faith that's referred to. Any presumption of good faith on the part of the prosecution when discharging its disclosure obligations is rebuttable. It's not an irrebuttable presumption. For example, we say, if the prosecution willfully refuse to misread the Court of Appeal panel decision and to deal with the obvious failings that were identified in that judgment, such willful refusal can rebut such a presumption. As I say, on this point, counsel attempted to resolve this issue through inter partes correspondence and was made perfectly clear in that the SPO was not seeking to address those failings whatsoever. They wouldn't do it. Moreover, and this is the final point, there is no presumption of competence. That doesn't appear in the rules. The SPO has repeatedly mischaracterized its own disclosure obligations. Whether deliberately or inadvertently, it has applied an overly narrow and restrictive approach to disclosure. Firstly, in good faith or otherwise, informing the court that a 13-item Rule 1023 notice met its disclosure obligations in full. Secondly, in good faith or otherwise, by wrongly dismissing the process by which the batches arrived at the KLAWVA premises as irrelevant. In those circumstances, any bold assertion that is made by the SPO that it does not possess any information on entrapment, frankly, is meaningless, when the SPO has never set out, for example, what it understands the scope and limits and the effect of the case law on the European of the European Court on Human Rights on police incitement is. It's never set that out. Yesterday, in fact, they told the trial panel that it has no legal relevance to the framework of these specialist chambers. I do not know, for example, whether... And I will be literally 4 lines in the notes.
I'm counting.
I do not know, for example, whether they accept the proposition that any information they have that any state official was involved in the process by which the batches arrived at the KLA-WVA premises is disclosable, or would assist us in looking at that circumstantial case on police incitement to support our plea. I just got no idea whether they do or whether they just reject that and say that it's legally irrelevant, as they told the trial panel yesterday. So we say that any bold assertion by them on entrapment is worthless. And of course, we have case law authority to support us in that proposition, because in Ramanauskas and Lithuania, the references in the pre-trial brief, at paragraph 72 of that judgment, they make it clear for obvious reasons that a simple denial by the authorities of incitement is not sufficient. It cannot be, for obvious reasons, because if it was, if that was enough to take the authorities' word for it, it would defeat all pleas of police incitement without anything further.
Thank you.
Well, very, very briefly, I just have a couple of brief ones. Just very, very briefly, I don't want to say that we're not grateful for your submissions, but your citation to a decision of the Court of Appeal of England and Wales, could you in future read out the case name that you're relying upon?
I certainly can. I apologise, I'll do that now.
No problem. And secondly, the page of Archbold on international criminal courts, just if you just read it into the record, the actual page number that you're relying upon.
The page number of Archbold on international criminal courts is page 533.
Right.
And in relation to the authority from the jurisdiction of England and Wales, it's West 2005, EWCA Crim 517. And I also referred, although I didn't specifically refer to the instrument itself, but I referred in part to material that comes from the Judicial Protocol on the Disclosure of Unused Material in Criminal Cases, issued in December 2013, paragraph 55, which provides that proper notice to the defence in ex parte applications should be as specific as the nature of the material allows and is necessary to enable the accused to make focused submissions to the court.
Thank you very much. And very briefly, I think as the Court of Appeal of this court correctly cited, Ramanauskas is authority for the proposition that the accused must be effectively able to raise an issue of incitement during trial to ensure compliance with Article 6 of the Convention. But it does not appear to be authority for the proposition that a rogue agent gives rise to a grounding of entrapment. No need to get into it right now, because in due course the presiding judge will be issuing an oral order, and you're free to provide the court with any further jurisprudence on the rogue agent argument that you've made.
I certainly do submit, and I will, if the effect of the order is to give us an opportunity to make further detailed written submissions, I will certainly do that. And we will look for other authorities, but I will maintain that Ramanauskas is authority that supports the proposition that a rogue agent, a police officer who does not act under the authority of superiors, etc., is nevertheless still responsible.
Well, we've all read the decision, and you can make the submission, but we don't need to go over it now.
No.
That's all we're saying.
Indeed.
Okay. Thank you. I wanted to be sure and preserve 1 minute for the prosecution.
Thank you, Your Honor. Before taking my minute, is it possible to go into private session for less than 20 seconds?
I don't know. Tell me down there, Vicky, can we do that for quickly?
Your Honor, we're in private session now.
Okay, we are in private session. Go ahead. We are in private session. Go ahead.
Apologies, Your Honor. It was in relation to the redaction order that we had requested through email, but we understand that a ruling has been made.
Yes.
So that was all. We can go back to open session.
We're back in open session, Your Honors.
Thank you. I will try now to keep to a minute. You heard a lot about the history of disclosure litigation in this case. Not all of it is accurate, but for present purposes, where are we right now? This is not about the order instructing the SPO to make submissions. We reference protective measures. This is another way of describing non-disclosure. Your Honor's order to us yesterday was to talk about redactions to the Rule 1023 notice. So you understood us correctly as it being a non-disclosure issue. This is not about the email notice that was serially referenced in Mr. Reese's submissions. They've had the email. We apologize for the way it was this morning. They've had the email for hours. They've had our full submissions for hours. We're in a different point now. Nor is this about the volume of materials. We did not make any submissions about the volume of materials. The passage quoted is still our position now. This is, again, not about the status of the Rule 1023 notice throughout this litigation, and the first one and the second one. I found it revealing on pages 9 and 10 of the real-time transcript. Mr. Reese, in referencing the Rule 1023 notice, said it was the second and final notice, at least until yesterday, which belied an understanding of the defense that was similar to ours, that the Rule 1023 notice issue was resolved by the Court of Appeal. When the Gucati defense says that a single issue was ruled upon in the decision, we wanted to focus on that in particular. That is not what happened in the impugned decision. If the Court of Appeal were ruling on a single issue and it had been resolved in Mr. Gucciati's favor, then their appeal would not have been dismissed. The only reason why the appeal was dismissed because there was a second issue. In the Gucciati defense's request leading up to the impugned decision, they did not say they needed notice in order to make disclosure arguments. If you look at filing 199, paragraph 61, their relief sought was disclosure. The information requested should be disclosed under Rule 103 or 1023 or otherwise, at the very least, listed on the Rule 1023 notice. It is only today that they are saying that they needed one to do the other. Where are we right now? We've explained why we made this application when we have. We've explained that it's under Rule 108. Rule 108 is what gives us the entitlement to make an ex parte submission on this matter. We are not skipping steps. As we explained this morning, there is a Rule 108 issue right now and a Rule 106 issue right now. And we are entitled to give that full information to the trial panel. This is not a referendum on the history of this disclosure issue. This is about right now. And what we're requesting now is to have an ex parte session with the trial panel to make the submissions necessary for your honors to rule on our application.
Let me shorten this up. We will grant your request for the ex parte session, which we will start as soon as possible.
Thank you, Your Honor.
Prior to leaving the room to have it set up for the ex parte session, I want to read oral orders, just in the interest of time, that we discussed yesterday and that we are issuing today. So oral order The first oral order, as said yesterday, the Gucati defense is ordered to file written observations, if any, on the draft order on the conduct of proceedings by the 3rd of September 2021. Second oral order, having received, second oral order, as having received the SPO's request for admission through the bar table, the panel further orders the SPO to make written submissions on the classification of these bar table exhibits by 6 September 2021. The panel orders the defense to respond to the bar table motions and the submissions on classification by 10 September 2021. The defense submissions shall be within a 6,000-word limit. The SPO may reply by 14 September 2021 within a 2,000-word limit. The panel is satisfied that these written submissions will be sufficient for rendering a decision on the matter, and for this reason, it will not hear further oral submissions in this regard. Third, that's the end of the second order. The third oral order, further to the submissions made during this conference, the Gucati defense is ordered to provide further jurisprudence, if any, on entrapment by a rogue agent, and to file a written submissions on the definition of public interest. By the same token, the Haradinaj defense is ordered to file written submissions on the legal basis relied upon them in respect of entrapment, and to provide any Kosovo legislation on whistleblowers. Both defense teams are further ordered to file written submissions on the question asked by a member of the panel, namely, what legal avenues are available to the SPO other than relying on national authorities when inquiring about evidence located on their territory. That's from the draft transcript, page 476, lines 6 to 10. The aforementioned submissions are to be consolidated in one filing per defense team, which shall not exceed 3,000 words, and are to be filed by 6 September 2021. Legislation and list of authorities can be annexed to the filing. That's the end of the third order. The fourth oral order, the panel orders the SPO to submit its request for adding one witness to its witness list by 7 September 2021, 1600 hours. The request shall not exceed 3,000 words. By the same date, the SPO is ordered to disclose any evidentiary material pertaining to the proposed additional witness and to submit a request for their addition to the exhibit list. The defense is ordered to respond, if it so wishes, during the SPO preparation conference. That's the end of the fourth order. The fifth oral order, the panel orders the SPO to submit a request for adding revised transcripts to its exhibit list by 13 September 2021. The request shall not exceed 3,000 words. By the same date, the SPO is ordered to disclose the relevant evidentiary material if it is not already done so. The defense is ordered to respond, if it so wishes, by 20 September 2021. That's the end of the fifth oral order. The sixth oral order, further to the submissions made yesterday, the panel orders the SPO to file its motion to strike defense witnesses and parts of their testimony from the proposed list by 15 September 2021. The defense is ordered to respond by 27 September 2021, 1600 hours. That's the end of the sixth oral order. The seventh oral order, further to the submissions of the Haradinaj defense, the panel orders that the expert report of its proposed expert witness, namely witness number 17 on both the Gucati and the Haradinaj witness lists, is submitted by 1 October 2021. The SPO is ordered to file a notice in relation to the expert report within the time limit and for the purposes provided in Rule 149, Sub 2 of the rules. That's the end of the seventh oral order. The eighth oral order, having heard the parties on their intention to file additional Rule 117 motions, the trial panel hereby orders that any other Rule 117 motions are filed by 17 September 2021. Any response thereto shall be filed by 24 September 2021. That's the end of the eighth oral order. The ninth oral order, having carefully considered the arguments raised by all parties in relation to the SBO request for protective measures for its two proposed witnesses, the panel hereby denies the request. Written reasons shall follow next week. That's the end of the 9th oral order. The 10th oral order. The panel reminds the parties of the deadline of 3 September 2021 to submit any outstanding translation or verification requests directly to the registry. Any future translation or verification requests should be submitted as soon as the need is identified. The panel reminds the parties that the eligibility and prioritization of the translation requests and the procedure to be followed are governed by the registry's practice direction on translation and interpretation and the registry instruction on requesting translation, interpretation, and verification services. For verification requests, the panel directs the parties to follow the procedure set out in the aforementioned registry instruction. These practice directions are to be strictly followed. And finally, the panel hereby schedules the SBO Preparation Conference for September 8 and 9, 2021 at 9:30 a.m. A written agenda will follow. Now we'll have a 30-minute break for court management to make the necessary preparation for the ex parte session. We will resume only with the SPO no later than 4:30. I'm sorry, 3:30, no later than 3:30. And I ask that we be notified and SPO be notified as soon as it is ready. And we ask the defense to stay in the building so that you can be recalled if necessary following the ex parte session. So we will take a break for 30 minutes.
All rise.
Ooh.
All rise.
Good afternoon. We're back in open session. For the record, we had an ex parte discussion with the SPO on the Rule 102.3 list, and we are going to issue an oral order in this regard at this time. This is the beginning of the oral order. Having considered the arguments of all parties, including those presented by the SPO in ex parte session, the panel decides to amend its oral order issued on 1 September 2021 and orders the SPO to provide to the panel only an unredacted Rule 1023 list providing detailed notice of the material, enabling a determination of materiality by the defense. The panel also orders the SPO to provide, again to the panel only, a proposed redacted version of the same list. Both of these versions should be submitted to the panel by tomorrow, 3 of September 2021 at 12 noon. The next steps will be indicated by the panel at the SPO preparation conference. That concludes today's hearing, and we will see you on Wednesday next.
All rise.